am one of your family law lecturers. Due to the short period that we have from now until the exams, we decided to do a recordings of our sessions in order for us to cover all the necessary information that will help you as you prepare for the exams. These recordings are a summary of the course content. You are still required to thoroughly go through your prescribed textbook as well as the study guide. You are also required to go through tutorial 102, which has been uploaded on the My Modules site. Today's recording is going to be about dissolution of a civil marriage. A civil marriage can be dissolved in 3 ways. The first one is through death of a spouse or both spouses. The second one is through an annulment of a voidable marriage. And lastly, it can be terminated through a divorce. With regard to death, it is important that you know that when the spouses are married or were married in community of property, the death is going to terminate both the marriage and the joint estate. And during the winding up of the deceased estates, the deaths that were incurred before the parties got married, the deaths that were made before the parties got married, that debt is going to be paid from the net half of the debt is going to be paid from the original debtor, irrespective of whether that debtor is the deceased or is the surviving spouse. So during the winding up of a deceased estate, debts that were incurred before the marriage are paid from the net half of the debtor, irrespective of whether the debtor is deceased or is the surviving spouse. And when it comes to spouses who are married out of community of property, the antenuptial debts, the debts that were made before they entered into a marriage, are not terminated by the death of the spouse. And also, you need to be aware that spouses who are married in community of property, the executor who winds up the deceased estate is going to wind up the whole joint estate, while spouses who are married out of community of property, the executor is only going to wind up the estate of the deceased spouse. It is also important to note that a surviving spouse who is in need of financial assistance or who still needs financial assistance to meet their basic needs can bring about a claim in terms of the Maintenance of a Surviving Spouses Act. And these claims can be brought by a spouse who is in financial need, irrespective of whether the marriage was in community of property or out of community of property. Now, annulment of a voidable marriage. Here, you just need to know that an annulment of a voidable marriage is a legal procedure or a legal process whereby a spouse or the spouses can bring a court application to have the marriage declared null and void. And when the court declares the marriage null and void, is going to be taken as if the marriage never existed at all. Now, divorce. Divorce is regulated by the Divorce Act. And in terms of the Divorce Act, there are 3 grounds that a marriage can be dissolved. The first ground is irretrievable breakdown of the marriage. The second ground is an incurable mental illness of a party to the marriage. And the third one is the continuous unconsciousness of a party to the marriage. And when we talk about irretrievable breakdown of a marriage, you need to be aware that in terms of Section 4, subsection 1 of the Divorce Act, the court may only grant a divorce of degree. It states that the court may only grant a degree of divorce on the ground of irretrievable breakdown of a marriage. And Section 4, subsection 2 lists the guidelines that the court can look at in order to determine whether a marriage has irretrievably broken down. To see these guidelines, you can go to page 121 until page 122 of your prescribed textbook. And Section 5 regulates the grounds for mental illness and continuous unconsciousness. Section 5, subsection A, regulates the ground for mental illness, and Section 5, subsection 2, regulates the ground for unconsciousness. You need to also be aware or note that the court does not have a discretion to refuse to terminate a marriage if it has been proven that the marriage has irretrievably broken down. The exception to this is Section 5, capital A of the Divorce Act, which applies when spouses are married in terms of civil marriage as well as religious marriage. So the spouses or the parties must have a dual marriage. Section 5, capital A, provides that if it appears to a court that granting a decree of divorce will result in either spouse or both spouses being unable to remarry because of their religion, unless the marriage is also dissolved in accordance with the prescript of their religion, the court can refuse to grant a decree of divorce unless it is satisfied that the steps will be taken to dissolve the religious marriage or to remove the bar to remarriage. So it is important to note, to remember that a court cannot refuse to dissolve a marriage, but the exception is Section 5, capital A. Now, the patrimonial consequences of a divorce. You need to know about settlement agreement. A settlement agreement is a document that sets out the terms of the divorce. For example, in the settlement agreement, the parties can agree on the division of the matrimonial assets, parental rights and responsibilities, maintenance, pension interest, and any ancillary relief. And secondly, you need to know about pension interest. You also need to know the difference between pension interest and pension benefit. It is also advisable to know the sections which regulates the pension interest and pension benefit. You need to be aware of forfeiture of patrimonial benefits. In terms of Section 9, subsection 1 of the Divorce Act, this provision or this section empowers the court to grant a divorce order on the grounds of irretrievable breakdown of the marriage, to order total or partial benefits. Here, it is important to note that a forfeiture of benefits can only be ordered if the marriage has irretrievably broken down. So if the marriage terminates because of mental illness or continuous unconsciousness, a forfeiture of benefits does not apply. It only applies if the marriage has irretrievably broken down. You also must be aware of the factors that the court consider when deciding whether to order forfeiture of benefits or not to order it. The other important aspect to note or to be aware of is the redistribution of assets. Section 7, subsection 3, empowers the court to redistribute assets from one spouse to the other. There are requirements, a prerequisite that must be met first for the court to order redistribution. Again, when it comes to redistribution, it is important to note that the position differs between non-Black spouses and Black spouses. Non-Black spouses is white, colors, Indians, Asians, as long as the spouses are not Black individuals. For non-Black spouses, for a spouse to request an order for redistribution, of assets. The parties must have entered into a marriage before 1 November 1984 in terms of an antenuptial contract, meaning that the marriage must be out of community of property in terms of an antenuptial contract. And the parties also must not have entered into an agreement regarding division of their matrimonial estate. It is important to note the date because any non-Black spouse who is in a civil marriage and is married out of community of property in terms of the antenuptial contract, but entered into the marriage after 1 November 1984, redistribution of assets will not apply to them. It is only limited to spouses who entered into a marriage before the commencement of the Matrimonial Property Act. Then, with Black people, there has been a recent legal development which was brought in by the Constitutional Court in the case of Sithole versus Sithole. But before I talk about Sithole versus Sithole, it is important to note that for Black people, redistribution of assets was applicable to them, or they could request the court to redistribute assets if the parties entered into a marriage before 2 December 1988, that is before the coming into operation of the Marriage and Matrimonial Property Law Amendment Act, and the parties were married in terms of Section 22, subsection 6 of the Black Administrative Act. Section 22, subsection 6 of the Black Administrative Act has been declared unconstitutional by the Constitutional Court, and the result of it is that, before I tell you the result of it, let me just go back just to make you aware that in terms of this provision, Section 22, subsection 6 of the Black Administrative Act, it has stated that all civil marriages of Black spouses are automatically out of community of property. Now, the Constitutional Court, in the case of Sithole versus Sithole, have declared this provision as unconstitutional, and all these marriages which were entered into in terms of this section are now automatically in community of property. Basically, this means that all marriages their spouses had entered into before 2 December 1988, which were declared to be automatically out of community of property, they are now automatically in community of property. Now, the result of this is that at the present moment, Black spouses who are in a civil marriage cannot bring in a redistribution, a claim for redistribution of assets. This is because in terms of the act, it could only be brought in if the marriage had occurred before 2 December 1988, and because now those marriages are declared in community of property, and for it to apply, the marriages had to be out of community of property. So those spouses are now protected because their marriages are now automatically in community of property, and then all other Black spouses whose marriages are out of community of property in terms of the antenuptial contract, redistribution of assets will not apply to them because in terms of the act, they are not covered. They fall after the date where this redistribution asset provision was applicable for spouses who are married in community, who are married out of community of property. So any black spouse and who is married, who is in a civil marriage, and any non-black spouse who is in a civil marriage and their marriages are out of community of property in terms of the antenuptial contract, and their marriages occurred, let's say for non-black spouses from 2 November or after 1 November 1984, and for black spouses it does not matter when those marriages for black spouses, if those marriages were entered into after 2 December 1988, those marriages are going to be governed by the terms of the antenuptial contract, and unfortunately the spouses cannot bring in a claim for redistribution of assets. Now, foreign marriages. Our current law states that when spouses enter into a marriage, they will follow the rules of the domicile of the husband's law at the time of getting into marriage. So this means, for example, if, for example, there's two sisters, there is a Rose who's getting married to David, and they are both South African, and there is also Kimberly who is getting married to Tab, who's getting married to Saul, and Saul is a Nigerian citizen. The first parties who are South Africans, their marriages automatically going to be in community of property because the husband is a South African, and the default matrimonial system in South Africa, it is in community of property. And the second party is because the husband is a Nigerian citizen. In Nigeria, their matrimonial system is opposite to ours in South Africa. Their matrimonial system is automatically out of community of property. So because the husband at the time of entering into a marriage, the laws of their country is automatically out of community of property. That means that the marriage of the parties, even when they enter into a marriage in South Africa, the marriage will automatically be out of community of property. Then Section 7, subsection 9 of the Divorce Act states that the South African court is empowered to give an order for a redistribution of assets if the governing laws of a foreign country also have the powers, or in other words, if their courts also have the powers to give an order of redistribution of assets. So, for example, let's use Zimbabwe and let's use Nigeria as an example. So, let's say Nigeria, the courts, they also have the powers to order redistribution of assets. So, if the courts have that powers, then it means the South African court, which is adjudicating a divorce, which is automatically out of community of property because the husband was domiciled in Nigeria at the time of entering into a marriage. The South African court will have the powers to order redistribution of assets. But should it happen that in Nigeria, they do not have a provision whereby the court can give an order for redistribution of assets, this will mean that in the South African court will also not have the powers to order redistribution of assets. So, in short, for spouses, or for a spouse who is married to a non-South African, whether the court is gonna give an order or the court has the powers to give an order for redistribution of assets, it will depend on whether the foreign country has that provision in their laws. Okay, now the constitutionality of Section 7, subsection 3. This provision does not apply to same-sex marriages. This is because the same-sex marriages only became legally recognized later on in life. And then one can argue that they are being discriminated against because there are spouses who can request the court to order redistribution of assets, while with them, the court don't have the powers to do that because the Civil Union Act does not make provision for that. Non-Black spouses and South African Black spouses who are in a civil marriage and who Section 7, subsection 3 does not apply to them. The Constitutional Court, in the case of Gumede versus the President of the Republic of South Africa, gave an order which extended the judicial discretion to redistribute assets to spouses in all customary marriages, irrespective of when those marriages was entered into. So basically what the Constitutional Court did in the Gumede case, it says if there is a spouse who may be in need that the court redistribute assets from their spouse's estate to their estate, the court has the powers to order redistribution irrespective of when the marriage was entered into and irrespective of the matrimonial property system of the parties. Remember, I said for non-Black spouses and for Black spouses before the amendment or before the ruling in the Sithole versus Sithole, for redistribution of assets to be applicable, the parties must have been in and out of community of property marriage. Now the position has changed. Now the position is different when it comes to those in customary marriages. Spouses who are in a marriage that is in community of property. In terms of the Gumede case, the court does have the powers to redistribute assets. But we know that when the parties are in an community of property, they are joint. They have joint rights to the estate, and it's 50-50. So I don't see a court ordering redistribution of assets in an community of property marriage, but the court can order redistribution of assets if the parties are married out of community of property without the accrual, or out of community of property with the accrual system, if maybe it can be shown that the spouse whose estate is higher gets to keep quite a large chunk of the estate, while the other one, their share of what they're supposed to get after the accrual calculation is quite limited. And this will occur when, let's say, in the antenuptial contract, the spouses have listed the assets that they do not want to form part of the accrual calculation, and the spouse whose estate is higher maybe gets to keep quite a lot, while the other one just really gets very little from the accrual calculation. And the other case is what I was talking about, which is Sithole versus Sithole. You also need to know the requirement for a distribution order. Okay. Now, the other thing that you need to know about maintenance of a spouse after divorce. You know, when spouses get married, there is an invariable, in other words, a right that comes with being married that cannot be changed. That is an invariable consequence of a marriage, a benefit or a right that spouses get by virtue of being married, and that benefit cannot be changed. One of it is the duty of the parties to support each other, to maintain each other. This duty of support comes to an end when the marriage is terminated. You need, under maintenance of a spouse after divorce, you need to know section what the section 7 subsection 1 of the Divorce Act states, and here or in terms of this provision, the spouses in a settlement agreement can agree with each other regarding the spouse who's going to be given post-divorce spousal maintenance, and the amount that their spouse is going to get, and the period when their spousal maintenance is going to come to an end. And you must also know section 7 subsection 2. This is when the parties have not entered into an agreement, but the court makes an order for post-divorce maintenance. You need to know the factors that the court take into account when they decide to order post-divorce maintenance. You also need to know the types of maintenance that the court can award through a divorce. Student, it is important to be aware that for a spouse to get post-divorce maintenance, they need to request the maintenance during the divorce process. Once the marriage has been terminated and the divorce has been made an order of court, a spouse cannot come and claim for post-divorce maintenance. So it is important to note that this is a process that must be done during the divorce process itself, so that when the court grants an order of divorce, the provision of maintenance will be in the divorce order. You also need to know when a maintenance order can be rescinded, suspended, or variated. Variation of a maintenance order. You also need to know when a maintenance order can be terminated. And here also you need to know the difference. When spouses have entered into a settlement agreement and a maintenance order has been granted in terms of their settlement agreement, the maintenance order will come to an end in terms of what has been agreed on in the settlement agreement. But in terms of section 7 subsection 2, where the maintenance, it is ordered through the discretion of a court, the maintenance will come to an end either when a spouse who's getting the maintenance gets married or passes away, or the spouse who grants them the divorce passes away, or it also comes to an end if the court has granted a rehabilitative maintenance, that is a maintenance for a short period of time, where the court says the maintenance maybe will be paid up until the next 24 months or the next 28 or the next 48 months. It will depend on the duration that the court has stipulated when the maintenance must come to an end. So student, this is just a short summary of what you need to know when it comes to dissolution of a maintenance, a dissolution of a civil marriage. As I have stated at the beginning of this recording, that student, it is very, very important that you study your prescribed textbook, you study your you study your study guide. And also, student, we have uploaded tutorial 102, which has all the latest legal development. You will also get a summary of the Sithole versus Sithole case in tutorial 102, and also the latest case judgment, especially the landmark judgment that have actually changed our legal position. Student, if you want to talk to us privately, if you have any questions or if there is something that you want to discuss with us, please feel free to send us an email and we can arrange a one-to-one, either a session through emails or a session on Teams, so that we discuss whatever queries you have. You can send me an email on monarkn, that is MONARKN @unisa.ac.za, or you can send an email or set up a meeting with Molebogang Sierrane at sierran@unisa.ac.za. Student, also, if you would like a copy of this summary notes of mine, feel free to send me an email and I will send them to you. But again, I emphasize that this is just a summary. It does not contain the cases that you need to be aware of. Others are on tutorial 102, others are in your textbook and study guide. This is just a summary to make it easy for you to understand what the content of dissolution of a civil marriage is. Student, I trust that this summary will make it easy for you to study, to prepare for your exams. Good luck with your studies, good luck with your exams, and we shall record, we shall do other recordings for other topics that you must be aware of, and we'll make sure that we upload all these recordings before you start writing your exams. Thank you, students, and all the best with your studies. Thank you.